Welcome, everybody. My name is Stuart Discount. I'm the chair of the Enterprise Communications Advocacy Coalition. We'll just use ECAC because that's a mouthful. Welcome to our monthly webinar today. It's on TCPA Critical Alert. Really good discussion about the National Reassigned Numbers Database. And I think you'll find it interesting. We have a tremendous panel. Before I introduce our panelists today, if this is the first time hearing about ECAC or the first time on a webinar, we're a 501c6 trade association designed as a mission to advocate for the contact center industry, to go to the FTC, FCC, and Congress on behalf of our member partners. In fact, yesterday we had a meeting with the FCC on their proposed rulemaking on outsourced call centers overseas. That'll probably be released or voted on next week. We have monthly webinars on great issues. Our member partners actually contribute to us by giving us the information for us to develop policy. So we poll our member partners on issues when there's a proposed rulemaking, if there's Congress has a new regulation. We gather information from our member partners because they're the ones who are operating and they're the ones that have the information. And then we develop that policy. We also provide our member partners with a lot of information like this webinar, but keeping them updated on legislation and issues that will affect them. You'll be receiving a copy of this webinar. We put this on our YouTube channel, and we'll give you the link to that. We'll also be reaching out if you're not a member partner to really talk about why you should be. The more members we have, the more data we have when we go to Washington on behalf of our member partners. So I hope you join us in the future. And from that, I'm going to go into today's panel. Before I start, there are a couple lawyers on our panel. Anything said is more a personal opinion. This is not legal advice. Yes, every situation is different, and you should consult your own legal counsel for issues like that. And I don't know if that's a good enough disclosure for our panelists, but I'm going to go into right now introducing. First, we have Megan Rose. Megan Rose is a senior consultant at Compliance Point with 9 years of telecommunications compliance experience, specializing in TCPA, TSR, and state telemarketing laws. She works with organizations to help operationalize regulatory requirements while managing enforcement risks. Next, we have Kelly Bubeck. Kelly Bubeck is the founder of Bubeck Law and a trusted advisor to businesses across the U.S. and internationally with nearly 15 years of experience in telemarketing and data privacy law. Kelly has defended more than 75 nationwide TCPA class actions in hundreds of individual cases and regularly represents companies before the FCC, FTC, and state regulators. She also advises clients on compliance and enforcement matters. Kelly previously served as a partner at a boutique law firm where she worked with clients ranging from global retailers to tech startups and political organizations. She also founded and led the firm's data privacy practice and earned her CIPP U.S. certification. She played a key role in the landmark Supreme Court case Barr versus American Association of Political Consultants, helping lead the First Amendment challenge to the TCPA. Kelly's a graduate of Northwestern University and the University of Kansas Law School. And last but not least, we have Mark Silver. Mark is a partner on Denton's litigation and dispute resolution team in Atlanta, where he focuses on complex civil litigation, including business, consumer protection, and unfair competition matters. Mark has extensive experience defending companies in class actions under the Telephone Consumer Protection Act and similar state laws across the country, as well as other major federal statutes like the FDCPA, FCRA, and EFTA. He also regularly advises organizations on compliance with these regulations. Before joining Denton's, Mark clerked for the U.S. Court of Appeals for the 11th Circuit. He graduated at the top of his class from the University of Georgia Law School and earned his undergrad degree in economics with honors from the University of Georgia. So welcome all. And right now, if you want, there's a chat box. You can put questions in the chat box, and if they're if they're talking something about something you want to hear now, we'll get to that at the end. If not, we'll do it at the end. So with that, let's get into this. So Megan, maybe we start with you. Can you give a little background on really what the reassigned number database is? Why the FCC decided that this was so important, and just give us a little bit of history.
Sure. So prior to the reassigned number database, there was a one call safe harbor. I want to say this came out in around 2015. And in 2018, that was invalidated by ACA international ruling in the DC courts. It basically said the one call safe harbor was arbitrary, hard to enforce. You didn't really know. So pretty much back then, if you called a party, whether or not they answered, whether or not it was dispositioned as wrong number, that was your one call to call a reassigned number. So the FCC, after the ACA international ruling, came back and said, okay, we are going to establish the reassigned number database. Carriers have to provide all disconnected numbers every 30 days, and callers can query the database with a date and figure out if a number has been reassigned since that date.
That's great. How many numbers are on the data on that database?
So it's actually grown since it was implemented in 2021. And as of January this year, there is roughly 600 million records on the reassigned number database. And that steadily increases every month. I want to say about 23 million records are added every quarter. And you don't really see any spikes or anything. That's a pretty steady increase.
I just wanted to chime in and give
Yes.
like a little
Yeah.
bit background, Megan, which your points are great. Um, for people who might not be as familiar with the TCPA, I hope you are, and the reassigned number database, but if you're calling a consumer, right, and for any sort of marketing promotional reasons, you're going to need at least prior express consent. If those are pre-recorded using a certain type of dialer called an ATTS, you're going to need prior express written consent. So the issue with reassigned numbers is most companies say, hey, I've got consent, I feel good, they opted in, I comply with the TCPA. But we know that people change numbers all the time, right? And so if you continue to call these consumers, and let's say the person opted in a year ago, 2 years ago, there's a decent chance that number has been reassigned, right? So if you call that number anyway, it's the wrong person. Well, you don't have consent under the TCPA. And that's where we see, these huge problems with TCPA violations and potentially class actions, which we'll talk about later. So I think that's why this reassigned number database is very helpful, particularly after the one call safe harbor was invalidated in 2018.
I agree on that. So um, it's expensive, Megan, right? To run this?
Yeah, it can be
Yeah.
expensive. It's sort of a subscription model right now. So you pay for an allotment of queries, and every time you ping the database, it counts against your queries. So there are different tiers, but that's one of the biggest drawbacks we see with our clients wanting to start using the database is the cost. And the FCC recognizes this. They implemented a price reduction last year. I don't think it was a substantial price reduction, but they do acknowledge that it is expensive.
Yeah, I've been hearing a lot of that too. And I think that's why some of the people are staying away from it. But we'll talk about that at the end, the cost, benefit, and risk. Um, Mark, how does it work? And what information is returned from a query?
Great question. So thank you both for the introduction. How it works, just so everyone kind of builds off of what we've heard, is as Kelly said, you have your date of consent. So let's say you got consent from someone a year ago today. So 3/19/2025. You put that in, or you use another organization who has a contract, such as Compliance Point or one of the other many companies, and they query that against the 600 million phone numbers to see if there has been a permanent disconnection of that telephone number after that consent date. So let me be very precise that it is called the Reassigned Number Database, but it doesn't actually show you whether the phone number has been reassigned. It shows you whether it has been permanently disconnected after a date, which again, you would only care about the consent date. So the database will respond to you with a yes, it has been reassigned. No, it has not been reassigned, or excuse me. Yes, it has been permanently disconnected. I want to be very precise. No, it has not been permanently disconnected, or no data, which we can talk about in a little while. That will be frustrating, but for reasons we'll talk about in a little while, you would still get protection if you're still running it, get no data back, and there was something. So you'll get your list. You'll see, let's say 500 yeses. Those are the ones that you really want to be flagging as, hey, there is a substantial likelihood that the individual who I am texting or calling or thought about texting and calling is not the same person who I got consent from originally.
Okay. I think, you said they're really just disconnected. I think a lot of people don't really understand that they haven't been reassigned necessarily. They just,
correct.
Yeah.
And what most of our clients will end up seeing, again, I'm very glad that all of you are on here, so you will have heard of this. Most of our clients, and I know Kelly has the same experience, when they get hit with one of those lawsuits, they don't even understand that this exists. But when you actually go back and look at the call or text records, you'll see, text message completed January of 2025, February of 2025, and then you'll see like a 3-month time period where it says, not completed, not completed, not completed. And then you'll see the text messages pick back up, which is normally around the time after about 3 months. And Megan may be able to get more information on exactly how much time frame, but generally after a number is permanently disconnected for 3 months, it is then put back in the cycle of getting an additional consumer. So your call records also should be able to help you tell if you have a substantial period where they're not going through, it will probably hit on the reassigned number database as well.
And just for information, texts are the same thing as a call. So under the TCPA, at least that's what the FCC says. Some courts are differing on that, but it's not just calls; it's actually texts as well, which I think a lot of retailers can get in trouble there because they are getting consent from people who are buying purchases from a website, and they get the consent, and then all of a sudden that person doesn't have the number anymore, and you're still trying to sell them. I mean, so texting is a big part of this.
Yeah, there's no distinction under the TCPA for text versus calls. I know that there's a lot of there's a split right now in some district courts, and I know Mark, you worked on one of these. And you did great regarding this issue, but there are arguments to be made that texts aren't technically calls under the TCPA because that's not what the statute said. But for compliance purposes, you want to continue to treat text as calls. So if you don't have the appropriate level of consent, you don't text them, right? And the same thing, the reassigned number database will also apply to text as well.
So there is a safe harbor. Mark, maybe you want to talk a little bit about what is that safe harbor, how it can protect you?
Yeah, so just a brief lead up, building off what Megan said, before the FCC said, hey, you get one call or text to figure out that it was reassigned. If not, you're liable, ha, ha, ha. And as Megan also said, of course, the vast majority of the time, if it's been reassigned, you're not going to get someone pick up and say, hey, this is the wrong number. Thank you so much for the miscommunication. Have a great day. Please remove me. Most of the time, they just ignore your telephone call, and then you keep calling them based on the consent you had. So the FCC, when they enacted this reassigned number database, they wanted to, frankly, encourage people to use it. And so they enacted a safe harbor, which says, hey, if you run this reassigned number database against all of your contacts and run it every 30 days and run it correctly, which again, if you use a third-party vendor, you should be fine. And if you do it, maybe talk with your attorney. then if there's a mistake that happens, if a number says, no, it wasn't reassigned, but yes, it was actually reassigned, and you call them, then we're going to protect, not we're going to protect you, but you have a legal defense to say, I did everything I needed to do. I'm not actually liable, even though technically you did make telephone calls in violation of the TCPA. Kelly, do you have anything kind of to add to that?
I mean, I think you touched on all the high points. Again, like you said, it's an encouragement. So there is no requirement by the FCC or federal regulations to use this database. It's still optional. But the fact that you get this safe harbor if you use it is extremely important, particularly if you're a target of a TCPA class action, things like that. Any company that makes a lot of outbound calls is going to inadvertently call a reassigned number, right? It's statistically probably impossible not to. So by using this database, you're really going to reduce the risk here.
And just to chime in really quickly too, because I know we always say record keeping is your best defense. If you are using the database, there's no storage on their side of which numbers are queried. So it's up to the burden of the caller to keep track of all of the numbers they're querying and the date and then the response that they get back.
And Megan, I assume your team kind of tells everyone, hey, we're running this. Well, actually, let me ask you a different question. Does Compliance Point, when you guys are working with companies, do you guys maintain the records, or do you tell your clients, hey, you guys should do it, or is it kind of a combination of both?
So I know if you use most third parties to check against the database for you, they do keep record of all of the queries. And if you try to query the same number within the 30-day grace period, it won't count against your allotment. So,
and I also want to stress one more thing there. So a lot of people say, hey, what if it gets reassigned, the day after we get the consent? Again, that's why they have the 30 days in there. One, if it gets permanently disconnected, generally my understanding is there's at least a 3-month time period, as I said before. But again, there is that 30-day period built in where they recognize you don't have to scrub this every day. That would be ridiculous and cost prohibitive. Do it every 30 days. And then if it returns a new phone number, then look at it there.
We do have a question from one of our guests. If the customer has opted in but reaches out to customer service for support and a callback is required, is that an exception since they are the party that engaged?
So I'll take this, and maybe Mark, you can chime in. I think this question is less about the reassigned number database and more about establishing consent or an established business relationship. I'm not sure where they're going, but if a customer opts in, then you have prior express consent, assuming it was appropriately done with in the appropriate way. If they don't subsequently opt out, then they're still opted in. Now, if they had opted out but then called back in for a customer service support, I would consider that reestablishing a business relationship. Again, I'm not sure quite how that applies to the reassigned number database, but that's just more about consent in an EBR. And in back to Megan's point about record keeping, none of this matters if you can't prove it. So documentation of consent or an established business relationship or anything like that is probably the most important thing when it comes to outbound communications.
And just to kind of piggyback on that, if a normal consumer reaches out to you on customer service and requests a call or says, hey, here's my phone number, then generally, as you said, you'll either have the consent, depending on whether it's informational or marketing, depending on language, or as Kelly flagged, an established business relationship. This is not, again, this is more about the reassigned number database, but I will tell you, if you're going to count on that, there are very specific rules on the established business relationship about the amount of time that you can call someone back. I have seen a lot of people make mistakes where they just put this number into a marketing list and continue reaching out to them well in advance. I will also tell you not to scare people. Unfortunately, I have seen a few situations exactly like what Nathan is asking in the question, and the wrong phone number is put in as well. Now, there's not too much you can do about that, but that does kind of tie into this wrong number / reassigned number database case. And it just further reinforces that if one of these phone numbers is put in, give them that quick call. If they don't pick up, maybe go back to the customer service and try to confirm that it's the correct phone number. Don't just start calling them 500 times because it may be a false phone number or something like that.
That is a little scary. As is the next topic is, how has this changed litigation? How has, what's been happening with the TCPA when it class action lawsuits? Because I think that the people are alarmed by some of the possible settlements that companies are actually making, and it's and I know, Kelly, you and Mark can talk a lot about this. So
yeah,
I
guess I'll.
Yeah.
Oh,
No,
Mark, you want to go? Okay.
No, go
Okay.
ahead, Kelly.
So now that we have this reassigned number database, we have seen a sharp rise in TCPA class actions related to, when I say a class is a group of individuals who are all sort of in the same situation. So plaintiffs' counsel wants to get a class certified because that's a huge group, right? And you can get up to $1,500 per call or text that was unlawful. So it's very easy to get, in theory, statutory damages of $50 million or something like that. So now with the reassigned number database, plaintiffs are said, if a company doesn't use the database and they called someone inadvertently and they bring a class action, they're going to say, you should have checked the reassigned number database. This was negligent, even potentially willful. And under the TCPA, damages can be trebled, meaning tripled, if they find knowing or willful behavior, such that you made a bunch of basically egregious calls. So we saw there's still an ongoing case, and Mark and I touched on this. There's a case called Elliott versus Humana. Everyone knows Humana is, a huge organization, and they inadvertently called some consumers, right? The numbers were reassigned. I think something like 26,000 people they incorrectly called. So, how do you defend against something like this? Defense counsel is going to say, well, it's an individualized inquiry. Every situation's different. So you need to look at all these calls individually. You can't certify a class. But what plaintiffs are going to say is, no, this is very obvious across the board. You didn't use the database. It was actively available, and you had a bunch of stale leads. That in itself is enough to certify the class. So if you're using very old leads, and when I say very old, I mean, I might even say 90 days, 60 days, 90 days, you should really be considering if this is a good tool for you. Mark, do you have anything to add?
Yeah, so I agree obviously with everything Kelly said. I also want to stress that recently I have seen plaintiffs' attorneys also filing these for calls made to actual clients or customers of the entity, not just marketing calls. And there are lots of consent rules. Again, this isn't about that, but generally this comes up when you're using pre-recorded messages. I've been involved with some very large companies that use pre-recorded messages, not just for marketing. Pre-recorded messages for marketing is very dangerous. You can do it, but very risky. But when you use it for your actual customers or clients, whoever you're reaching out to, generally it's a little bit safer. But I will tell you that if you have clients who have been with you for many, many, many years, there is a very large likelihood that many of those are going to be reassigned as well. So I want you all to be very aware that if you have large lists of individuals that you are reaching out to, not just marketing, that it is worth it to look into the reassigned number database as well, especially if you're using pre-recorded messages. I'll also add artificial intelligence. That's another big thing that we've been talking about a lot recently, and related technologies. So that's the only thing I'd add there. I see this is actually a question that fits in right now. Are there any exemptions for healthcare calls, texts related to scheduling appointments and appointment reminders? So that is kind of fitting in exactly what I was talking about here. So there is specific healthcare exceptions that apply really mainly to emergencies. But these healthcare calls and texts are, again, similar to what I was talking about earlier. If you're reaching out to remind people of their appointments, that's not a marketing message. However, there's not really an exception there if you're reaching out to a phone number that is not the intended recipient. So those are the exact types of situations here that of large companies that have been seeing some of these. Kelly, anything to add?
Yeah, just related to the response to that question, to further reduce risks for informational calls and things like that, for potential reassigned numbers besides using the database, like you said, Mark, don't make pre-recorded call reminders. Text them instead, because that doesn't trigger a different section of the TCPA and some restrictions. So again, there's no reassigned number database exemption, but there are ways to reduce risk in other ways. And that would be like my number one, I would say, suggestion to anybody is, can you stop using pre-recorded calls? Is there a better way? Can you text them? Things like that. And that's what I would recommend, particularly for informational stuff. People always open their text. Less people, I think, particularly younger people, are going to listen to their voicemails.
Yeah, so to the person who sent that question, again, like Kelly said, not a direct exemption, but ways to severely limit it based on the parts of the statute. I will tell you, though, that there are mixed messages, and I don't want to get too far off base, but this is very relevant, where people will be like, hey, just a reminder about your appointment. Oh, by the way, have you seen our new discounts for like XYZ? That will turn it into a marketing message, or could, and will elevate the amount of consent that you need.
So these obviously there's a lot of these TCPA lawsuits out there right now. How in some cases, how are they even the plaintiffs' attorneys creating these cases? I mean, because we know there's some serial plaintiffs out there. It's a whole cottage industry, basically.
So I'll start it. The nice way to say it is that millions or hundreds of thousands of these reassigns happen every day. So someone is going to get a reassigned call, get frustrated. People are being inundated with marketing about unlawful texts, unlawful calls. They'll reach out to someone and then they'll bring a lawsuit. What I will tell you is, for some of these individuals who are serial plaintiffs, etc., there is some thought that maybe they have purposefully gotten a reassigned number, and that they're not necessarily upset when they start getting calls that weren't meant for them. I want to clarify, though, because this is very important, that unfortunately there's not necessarily anything wrong with that from the plaintiff's side. The plaintiffs have every right under what the current law is. Well, there aren't any easy defenses under the current law to say, hey, this person intentionally, reassigned their number, got these calls, it wasn't on accident, and they shouldn't be able to recover from that. There are some standing issues and everything like that we can talk about later. But Stuart, I think that answers your question. I'm curious if Megan or Kelly have any additional thoughts there.
Yeah, I don't know if you two agree, but we have seen it in some demand letters that our clients get, where we'll go back and query the database and look and see when the number was added to the national list. And we see sort of a pattern of these numbers have been recently reassigned, and then a plaintiff comes in and buys them, and then they're added to the national list, and then they start getting calls, and then the demand letters go out. And I will say we've seen an uptick on those letters probably in the past 6 months or so. I don't know if either of you agree.
Yeah, I mean, I think it's a combination of both. I just because of the volume of outbound calls that companies make, there's going to be inadvertent mistakes, right? Maybe companies don't even know about the reassigned number database or can't afford it, or that's sort of another issue we're going to touch on. So there are going to be inadvertent violations of this. So normal consumers may get frustrated and reach out, right? So that's totally fine. And then there are also, serial plaintiffs who I do think, and this is, I would say, less frequent, but still happens, where they do get 3, 4, 5 phone numbers and they hope they get reassigned calls and they know some plaintiff's attorneys. But again, that doesn't invalidate their claim, but it doesn't, for a company that, tries very hard and spends a lot of time on compliance and things like that, it does it does stink, right? Because you're not trying to make calls to people that don't want them. You're trying to reach your customers or someone who consented, and mistakes happen. Now, should a mistake like that cost you $5 million? As a defense attorney, I think not. But I think plaintiffs would have a different answer. Plaintiffs' counsel would have a different answer.
Yeah, plaintiff's counsel, I'll just respond as plaintiff's counsel. Plaintiff's counsel would say these $5 million hits are necessary so that we can have these types of webinars and everyone gets their eyes open and stops making calls to bad people, even if you had good intentions. I'm not saying I agree with that. Look at Stuart's speech at the beginning regarding our personal views, but that is what they will tell you if you bring up, I was innocent, I was just trying to do the right thing. They'll say, this is making an example so that we stop these spam calls.
I think that's a fair assessment.
So what's the cost benefit for a mid-sized company to access the R&D? Is it worth it? I mean, the risk, the cost benefit?
Megan, can you tell us first, just like a general idea of how much the database may cost? Because I'm guessing a lot of people are interested in that.
Just a general idea. I mean, it really does depend on which tier subscription you're going for and how many different leads you're calling and what you think it's going to query. I will say a lot of our clients do find it cost prohibitive in order to use the database. So we always recommend you want to minimize risk where you can. And I think Mark might have touched on this about maybe being a little selective about which leads you're going to scrub against the database. Using maybe some older leads you haven't verified the phone number still belongs to the person, going for a lower subscription and only checking those, using a professional plaintiff list, which is a lot more readily accessible or more financially feasible for some mid-sized companies. Like I said, it really just depends on the tier level, but
Okay. I mean, I think hypothetically, if I had a client come in that, maybe could afford it, but it was going to be tight, I think I'd first ask them, let's make sure all the other compliance areas are buttoned up first. Let's make sure your consent's good, your record keeping's good. Let's do all that first. Then, inevitably phone numbers are going to be reassigned. And so I think, and Mark and I were talking about this a few days ago, let's say because it's based on the number of leads or number of phone numbers that you query, right? So, if you got the phone number, let's say 30 days ago or 45 days ago, and you were on a tight budget, maybe that's something that you could say, well, I'm maybe willing to take a little bit more risk with these numbers that just opted in. But if you have older data, and some companies hold data for a while, and that's a different issue. But let's at least, if you think you can do it, scrub the oldest leads first. So we minimize the risk from the oldest leads, which would be more likely to be recycled, and then see, depending on your financial situation or things like that, then maybe move to all of them.
and I will say too, sorry, Mark.
Go ahead. No, go ahead,
I was
Megan.
going to add in, generally, I mean, if you are calling people, you don't want to reach a wrong party contact. That's sort of just a waste of your time. But we do see on the client side, when they first start implementing the database, it is about 8% of leads that they have in their CRMs that are reassigned or permanently disconnected. And then once they start using the database more frequently, that number drops down to about 2%.
Yeah, and I think that fits perfectly with the comment that we just got,
Yeah.
which I come on and be a panel member.
Yeah.
That this is how I kind of sell it to my clients too. It does cost a lot. You guys can look at it. You can reach out to any one of us and we can kind of get you kind of hooked up, or again, you all can sign up yourself. But you're going to be saving the money, one, from a potential lawsuit, because these are coming. And two, you're going to be saving the reach outs. And, a lot of my companies, use third parties. And so you're paying, you have your customer time, et cetera. So it is the cost benefit analysis. One thing I want to harp on, and I always do this when I speak on these, and Megan briefly mentioned it, but this should have its own topic. The frequent litigator lists.
Yes.
These are lists that companies like Compliance Point and many other of their competitors, which is fine, go use any of those. I'm just using them as an example because Megan's on, have proprietary information where they have gone through and spent the time pulling the phone numbers and names of individuals and phone numbers that commonly file these types of lawsuits. There is zero, and I mean 0% chance that you should be reaching out to a single one of the phone numbers on those lists. I don't care if you think you have the most buttoned up lead and everything like that. These are individuals who make a living, most of them, on suing entities like you guys, and they say, oh, it wasn't me who put this in, etc. Those are not very cost prohibitive. I don't have one of the lists, again, these companies do, but every single one of my clients, that's pretty much the first piece of compliance advice I tell them, because that is much less expensive than running against the reassigned number database. And a lot of the people who are filing reassigned number database cases are frequent litigators.
Yeah, Mark, I think that's a great point. I also wanted to mention that take into account Melody's point, which is great. If you do get sued in a TCPA class action, right? Particularly for calls made to numbers on the do not call list, right? There's a safe harbor under the TCPA in a separate section, which allows companies to say, hey, we may have made an error, that we had reasonable practices and procedures in place to prevent these types of errors, and we did everything we can. So it's an affirmative defense. But if you use the reassigned number database, the serial litigators database, you have all the other internal policies, I think the use of this database, the RND, along with the serial litigators database, shows that, hey, we're doing everything we can to try not to contact people who don't want to be contacted. So I think that's evidence of it's not a waste of money in that respect either. It could help you in litigation as well.
And just to build off of that, Megan just gave some concrete examples that what she sees is before they scrub for the R&D, when they do it the first time, they're seeing about an 8% hit rate. And after they start doing that, it goes down considerably, very, very low. My point is to tie into what Kelly was saying is even if you do make mistakes, which everyone's going to make a mistake, especially when you're doing volume advertising or reach outs, you're significantly limiting the potential exposure that you have. So instead of 8% of your calling list, I don't know, you're looking at 0.5% or 0.1%. So that is significant, and again goes to the point of there really is a lot of ROI to implementing all of this.
Megan, how often would you recommend a company's scrub against the R&D? I don't know if we've touched on that.
Yeah, I think Mark might have mentioned it a little bit earlier. We typically recommend 30 days. You do have to use the most recent version of the database, which is updated every 30 days by the carriers with the new disconnects. A number is at rest for 45 days after, at least 45 days after it's been disconnected. So there might be a little bit of wiggle room if you wanted to stretch it, but we say 30 days.
And just to reiterate again, the safe harbor, which we talked about earlier, does require the 30 days. Again, I understand that that's going to be more cost prohibitive, and if you're trying to kind of minimize risks, you may want to run it less. I will tell you though that if you guys go and rub it or scrub it tomorrow, you're going to see some substantial reduction of your risk just running it one time. I'm not advocating for that. I always advocate my clients do it according to, the 30 days, get that safe harbor so we're most safe. But we do understand, obviously, that not all clients can afford that. And, try to do the best they can. And Megan may be able to talk about this, but there are very strict limits on who can access the reassigned number database and kind of disclosures that are used that I would think should prevent any sort of type of use like that. And hopefully would just encourage companies to say, hey, I'm just using this to prevent, calls to people moving forward. Megan, do you have any kind of, I don't know if you personally have gone to the reassigned number database or anything like that?
No, I personally don't. And I know Mark keeps referring to Compliance Point, but Possible Now is our parent company and they are the third party service provider. So that's more their wheelhouse. So I can't really speak about the limits there.
Got it. And Kelly, do you have any kind of experience? Well, I know you've been working on some of these cases for the reassigned number database too. So just kind of curious
but
as to
not,
your experience.
yeah, I mean, I don't have, I have never accessed it myself. I haven't decided to be a lead generator yet, just quite yet. I'm saying that in jest, obviously, but yeah, I mean, I don't think I have anything to add there, unfortunately.
And I know people are putting in the chat, there are many companies, including probably members of this organization that will help you guys with litigator lists and R&D certification. And I cannot stress enough that if you're reaching out at all, you need to reach out to one of these companies or scrub yourself, but especially that litigator list. That is very, very important.
One of the things the ECAC board we're talking about is, what's the fix? What can the fix be? One thing is going, as Mark, you were just talking about, going to the FCC and saying, it should be used for the purposes you intended it to be. The other thing that we're thinking about is that the private right of action is going crazy. I mean, it's just not the intention of what Congress had. It was an individual who got, was called, and they were on the do not call list or some other TCPA infraction. And we're going to make an attempt to at least educate Congress that this is something that is costing businesses millions of dollars. Businesses are, it's not going to stop the scammers anyway, because the scammers out there aren't, they don't abide by the rules anyway. And that maybe there should be a fix to this, that we're, somehow that this can't be used in a class action. I don't know, but they could change something. They could get rid of the private right of action. I don't think they will. But that could be. Here's a question. Yeah, go ahead.
Oh, go ahead.
Kelly.
Oh, go ahead with the question, actually, and then
Okay. So if you scrub every 30 days for state and Fed, DNC, connected, disconnected, phone type, and known litigator, you're saying you should be subscribing to an R&D provider too.
Is this question with or without consent? It sounds like is the question. But I assume if they're scrubbing against state and federal do not call list, they don't have any consent or EBR. So I think the answer is yes.
Yeah.
You should, I would, well, I see what they're saying. I mean, it depends it depends how, like the volume of your calls. Hold on, they're giving more information. I think it just goes back to, without getting sort of in the weeds of this question, I think it depends on the volume of calls. If they are truly, you don't need consent to make them, they're live calls, they're not on the federal do not call list, then it maybe doesn't matter as much. But I would still recommend the reassigned number database generally.
Yeah. So, and again, they're coming in with more. So
it's kind of hard to follow.
Yeah, but so generally the reassigned database is most helpful, of course, when you have the consent, right?
Yeah.
Because the reassigned number database, one of the data points is you put in the consent and you see if it's been reassigned afterwards. If you are calling or texting without consent, which again is a totally different webinar that Stuart's probably already done or may do in the future. But if you are doing that in a compliant way and you are scrubbing for the most recent versions and you are abiding by state laws, which also have more limitations on non-consented to calls. For example, Texas requires registration, etc. If you are doing all of that, then the need to scrub against the reassigned database is much lower because you don't have any of the consent. You're not evaluating that consent against, you're not saying, hey, I have the consent and then I'm contacting them. You would really mostly be interested in those federal and state do not call lists, because obviously you don't want to be reaching out for marketing purposes more than once within a 12-month period to a phone number on the state or federal do not call list. So
And the calls would
think,
have to be live or text.
Yeah. And I think that was kind of in there. Again, there's a lot of assumptions in that question, but
Yeah,
assuming
yeah.
that they're not auto-dialed, and again, assuming no AI and stuff like that, then the reassigned number database would not be at the top of your priority list.
Yeah. Stuart, I do want to go back to your question. You know, I know you said your organization is advocating, for changes and do I think they're going to remove the private right of action? No, I do not. So what's the next step? Well, could they just remove the class action component? Because that's the real issue here, right? The liability stems from the fact that, okay, I may have screwed up once. You know, it's $500 to $1,500 per illegal call or text, which when Congress passed the TCPA in 1991, the reason that statutory penalty was so high was so it was enough to incentivize a consumer to go to small claims court and collect $2,000 or whatever. So now we see these class actions where it could be potential catastrophic damages of 100 million. Again, I don't think Congress is going to change that soon. Do you, Mark? I don't see that at all.
No, I don't see them changing that.
I don't either. But I think the plaintiffs bar would push back pretty hard on that. But, and this is sort of slightly off topic, but for everyone listening, a way to reduce class action risks beyond the actual, making sure you have the appropriate consent and all things like that is an arbitration clause. When someone opts in on your website, you need to have a statement. And again, this is my personal opinion, talk to your lawyer. But within the consent language, you need to have a statement that says, I agree to the terms and conditions, which are hyperlinked. Within the terms and conditions, you have a class action. Yeah, in blue. It has to stand out. There's a lot of things. I could go on and on, clear and conspicuous. But it has an arbitration clause and a class action waiver. And I've even, you can even put it in the consent language. I agree to the terms and conditions, hyperlinked, etc., including mandatory arbitration. Like that is a way from a compliance standpoint to help prevent these class actions. Again, not necessarily about the reassigned number database, but everyone that's opting in, it's a good way to sort of prevent these class actions.
And not legal advice, talk to your lawyer, but please consider putting that language above the submit button or everything like that. It's not, there are some good cases that we can work on, but it's much stronger if it's above there. We also got a really good question here. How do you handle the cases where the consent was valid before reassignment, but becomes invalid afterwards? So good question. So that's generally what Megan's referring to about, what they normally see about 8% when they scrub normals. So when you do that, what you should do is you should stop calling or texting that phone number, because there is a extremely high likelihood that the individual that you are reaching out to is not the intended recipient. Now, if that is a customer of yours, then what we normally have done, remember, we're just talking about calls and texts right now. This is not having to do with email, US mail, door knocking. There's, laws about all of this stuff too. And I know everyone's laughing about door knocking, but there are different ways that you can try to get a hold of your consumer to update your contact information for them. And the most effective way I generally find is that email. And again, this is a totally different presentation, so we won't get into this, but email communications are far, and I mean far, far, far less risky to your corporation.
Absolutely.
And I mean far less, like 99.9% less risky to your company. So you don't really have to worry as much about the reassigned emails or anything like that. So what I would recommend, if you call up one of these companies and they scrub your list and you get 8% back or even 1% of your numbers back, is you immediately stop contacting those. You remove those phone numbers from your list if your consent was from before the date of permanent reassignment. And then if it's a marketing call and you only had that phone number for this person, then you might have to chalk it up to, okay, we lost that marketing lead. Let's hope they come back another way. If it's, again, one of your clients, then try to get a hold of them another way. Kelly, Megan, any other thoughts?
I would second the email. There's, like you said, it is so low risk, any sort of email communications. And again, we won't get into that, but that would be the number one way. You could send them an email and say, hey, has your contact information updated? Click on this link for a form fill. Provide your new information, then it goes into your system. I mean, or a callback number, whatever, but email would be my advice too.
Yeah, agreed with that as well, because you have to remember if a number is on the R&D, that means it's been permanently disconnected. It's not just like somebody forgot to pay their phone bill and it was shut off for a little bit. That number doesn't belong to the person you're trying to reach, so you don't want to call that lead anyways.
Kelly, do you want to handle, I think we just got two more kind of comments in there.
Sure. Oh, okay. This is back to, well, the arbitration that I was referencing. So if you are a third party vendor and you're going to, benefit based on, so like, let's say you're a consumer and you opt in on a website, company A, but company A is going to use that and sell those leads to company B. What she's talking about is that in the terms of use, which I was talking about is a good way to have a class action waiver and an arbitration clause, you as that third party, company B, should ask company A to make sure that that arbitration clause covers you. So a third party beneficiary situation. That's a little bit in the weeds for this, but
very important in the weeds though.
yes, it is very important. So if you're, getting leads from other companies, ask about third-party beneficiary language in their terms of use and arbitration. I could do a whole thing about arbitration too. That'd be great. Yeah, so that's sort of that. I don't know if you want to take the other one, Mark or Megan.
Yeah, there was another quick comment about emails can be risky too. Again, don't want to go on a whole hour about emails. They can be, but generally not for, this type of reach out. There are some, states that are getting more stringent, including, for example, Washington State is enacting a pretty specific requirements about misleading headers and, being very clear about who the sender is of emails. And there's been an influx in private action litigation in like Washington State. Those are scary lawsuits. I'm handling some of them, but just remember, not that this necessarily is great news if your email volume is still big, those are still limited to like Washington consumers. When we're talking about the TCPA, generally that's nationwide liability, which, generally is obviously a little bit more scary. Yep.
We're coming down close to the top of the hour. First of all, Melody, thank you for your comments. You're our fourth panelist. Thank you very much for that. Some closing comments that you guys have. This has been great. You got about 4 minutes left.
Sure. I'll just say, just in general, if I could sort of sum up, the reassigned number database it's a really good tool. You should use it if you can afford it. If you can't afford it, try to minimize risk in other ways. Speak to an attorney about that. And lead with your oldest leads. If it's just a volume issue based on the cost, run the oldest leads first. And it can certainly help you. And again, the serial litigators database is great as well.
Megan, you want to go next?
Sure. I will also chime in and just say, like Kelly said, leading with your oldest leads, but also just maintain good records. If somebody comes in for an appointment and you verify that they still own the phone number, that moves your date up a little bit. So it might not be your oldest lead. And I know we've harped about the tiers and about the cost of the database just depends on volume, but that's all available online. If you want to go to reassign.us/pricing, you can look at the tier list and see if it's even a feasible option for you.
And my last thought will just be building off of those two, that, this presentation and the reassigned number database to me should be looked at holistically as part of your just cleaning up and your best practices, stuff. I tell my clients this a lot when they're resistant to, running against the reassigned number database and scrubbing. If you have a phone number on your list that has been on your list for 6 years, and you have been texting them, spending the effort and everything, and you haven't gotten a single reach out from them in 6 years, you haven't gotten a text back, you haven't gotten an open of that text, you have called them, you have emailed them, and there's nothing there. I'm not going to say never you might not get a reach out, but that is an example already, even independent of a reassigned number database issue or anything like that, of the types of situations of like cleaning your database, just keeping stale stuff off there. Now, again, if you have a 6-year-old lead where they've purchased from you every year, that's a different story. But just maintaining your marketing and client lists as clean as possible is something we all should strive for. And I just want this reassigned number database presentation to be put into that context as one tool you can use.
It's a great way to sum it up. Absolutely. Panel, you were great.